Now, let's come back home where the Electoral Amendment Bill has now been signed into law by President Matamela Cyril Ramaphosa. It will allow for independent candidates to contest positions in the National Assembly and provincial legislatures. But there are requirements that must be met. These include the inspection of copies of lists and their accompanying documents, among others. Let's find out what all this means from Terry Tselane. He's the chairperson of the Institute of Election Management Services in South Africa, and in days gone by, he was at the IEC. Terry, good afternoon. Welcome to today. Your reaction when you heard finally that the Electoral Amendment Bill has now been signed into law. I'm aware that the IEC itself is going to comment on this a little bit later this afternoon.
Thank you very much for having me. I think the fact that the Electoral Amendment Bill now has been signed into law was supposed to usher in a new era in the electoral landscape. But unfortunately, there remains quite a number of issues that have not been resolved. And then these are the areas that are going to be causing a little bit of inconsistency, rather a little bit of discomfort moving forward to 2024. And I'm not too sure what the reaction of other civil society organizations that had threatened to challenges would be in relation to those issues, particularly the issues that have not been attended to.
So we should expect some legal challenges then?
There is a possibility, particularly because, as I've indicated, there are quite a number of areas where there are weaknesses in this Electoral Amendment Act. And unfortunately, some of the issues that had been raised before Parliament did not have an opportunity to address those issues. And I think the fact that the minister has actually decided in the bill or in the act to establish what he calls electoral reform consultation panel is a clear illustration that indeed this Electoral Act or this Electoral Amendment Act does not actually deal with all the issues that are supposed to be attended to, and then therefore it is very defective in many respects.
It's very defective. What are its biggest weaknesses, in your view, Terry?
Well, the way the independents are being treated in relation to political parties, there is very serious inconsistency there. And I'll give you just one example. Firstly, if a political party requires to participate, those who are now in Parliament, that they want to participate in the elections, they don't have to go and get the signatures of all individuals who are supporting them. Of course, they've gone through a particular process, and then therefore there is no requirement for them to do so at this stage. But most of them got in by getting 500 signatures to get into Parliament or to register as political parties. And then now there was an amendment that was made where a political party would require 1,000 signatures to be able to participate in an election. However, this time around, the independents, together with new political parties, would require 15% of what would have been required to get a political party or to give a political party a seat in the previous elections. Now, what does this mean in real terms? In real terms, it means if a political party needed 45,000 votes in order to get into Parliament in the last elections, it means an independent now must be able to get 15% of those 40,000 votes, which would be about 6,000. And it might be a very difficult endeavor for an independent with little resources to be able to harness all those resources to get the 15% support. But that's the first aspect. The second aspect is that, when Parliament looked into this, they did not actually look into other related legislations that have got an impact on the scheme of things as we have them now. And another example is that, for instance, we've got what we call Party Political Funding Act. Party Political Funding Act basically obliges political parties to comply with certain requirements and also to get funding from the fiscus once they get into parliament. Now, independents do not, firstly, they do not have that privilege. Even if they manage to get seats, they are not covered by the Party Funding Act, and then therefore they will be treated differently to political parties once they have actually occupied their seats. But also the fact that the political parties do not have to forfeit the votes that they have. And if, for instance, an independent is contesting more than two constituency or regions, and then gets the votes, gets elected into one area, forfeits the other votes that they've actually received in another area. So those are some of the inconsistencies that exist between how political parties are treated and how independents are actually treated.
Yeah, Terry, thank you very much for your explanations and insights. We're going to have to wait and see who's going to fire the first legal challenge shot in terms of this, because I can see it's going to come. Thank you very much. That's Terry Tselane, elections expert.